Let's talk about the criminal charge of possession of a firearm by a convicted felon in Louisiana. Now, this is a very serious charge with serious consequences. State prosecutors do not like to help defendants with these charges. However, we know the gun charge defense is at work and how to use them. So why are felon in possession of firearm charges so serious? Felon in possession of firearm or guns is serious because the penalties are so severe. If convicted, the defendant must be imprisoned at hard labor for 5 to 20 years without the benefit of probation, parole, or suspension of sentence, and be fined not less than $1,000 nor more than $5,000. That means that he cannot get probation. If convicted, he must do prison time for at least 5 years, and the judge may consider all the facts and circumstances surrounding the gun charge to determine the amount of time to give the defendant. The judge may consider how long the defendant has been off of probation or parole for the underlying felony. The judge may consider what the underlying felony was and the number of prior felony convictions. The judge may want to know if the defendant was involved in drug dealing activities during the new arrest. All these issues may influence the judge's sentence. So who can't possess a firearm? Not every convicted felon is banned from possessing a firearm in Louisiana. However, according to federal law, no convicted felon can possess a firearm. If convicted of the following types of offenses, the individual cannot possess a firearm in Louisiana: felony crime of violence, simple burglary, burglary of pharmacy, burglary of an inhabited dwelling, unauthorized entry of an inhabited dwelling, felony illegal use of weapons or dangerous instrumentalities, manufacture or possession of a delayed action incendiary device, manufacture or possession of a bomb, possession of a firearm while in possession of or during the sale or distribution of a CDS, felony drug charge, any sex offense, any crime defined as an attempt to commit one of the crimes above, and felony domestic abuse charges. How long before a convicted felon can possess a firearm again? If the defendant is convicted of one of the charges above, he cannot possess a gun for 10 years after the date he completes his sentence. This will be the date he finished probation or parole. For instance, if he's convicted of possession of cocaine on January 1st, 2018 and sentenced to 2 years of probation, the 10 years will start after January 1st, 2020 if this probation is terminated then. This is Louisiana law. The federal government does not have a period of cleansing. Therefore, if convicted of any felony, the feds don't allow possession of a firearm. What types of firearm cannot be possessed by a convicted felon? According to the Louisiana legislature, the following weapons cannot be possessed by a person with certain felony convictions: pistol, revolver, rifle, shotgun, machine gun, submachine gun, black powder weapon, or assault rifle. What does the state have to prove? In order to present sufficient evidence that the defendant was a convicted felon in possession of a firearm, the state must prove the following: that the defendant possessed a firearm, that the defendant was previously convicted of an enumerated felony, that the absence of the 10-year period of limitation, and general intent to commit the offense. Now, I hope this video helps you understand the charge of possession of a firearm by a convicted felon in Louisiana. If you need a criminal defense attorney for this charge, give me a call. I'd be happy to help.